Officer Day, would you open my courtroom, please?
State of Michigan 36th District Court is now in session. The Honorable Judge David S. Robinson Jr. presiding. Good morning, everyone.
Good morning.
Good morning.
Let's call our case and get this pretrial started. We are on the record calling case 20158-865. The file is entitled Trustees versus Kirk Hogan, Sheila Hogan. Date and time for pretrial, your respective appearances.
Michael Mills, M-I-L-L-S, appearing on behalf of the plaintiff,
Bar number.
P29209.
Good morning, everybody. Ron French appearing on behalf of the defendants, the Hogans, P number 66393.
All right, gentlemen, is our discovery completed now?
This is Mike Mills. As far as I'm concerned, it is.
Mr. French?
Yes, it is, Your Honor. We had a request out for some items, but I think we've worked that out, so we're finished with it.
Okay, so your discovery, gentlemen, is now closed. Are either of you anticipating dispositive motions?
Michael Mills, yes. I actually plan on filing our motion later this week.
Okay, Mr. French?
We will respond, Your Honor. I am looking into possibly filing. We're not sure we're going to be filing yet.
All right, well, I'm going to do this, gentlemen. I'm going to give you a date for our next pretrial. And we'll see what happens, if anything, by way of our dispositive motions, but your discovery is closed as of now. May 11th,
Right.
11th at 10 o'clock is our next date. Does that work for both of you?
It'll be by telephone again, yes.
Mr. Mills, I don't think I'm going to have it in person this year.
Yeah, that's what I thought. I may be traveling, but I can do by telephone.
Okay. And what about,
That date is okay with me as well.
okay, May 11th at 10 o'clock, and there'll be a Zoom hearing again. Like I said, John, the way the COVID numbers are going, I don't see doing it in person this year. I really don't.
Yeah, it's getting pretty bad again, unfortunately.
Yeah, we seem to be going backwards. We're doing well, and now we seem to be going the other direction. So what I'll do is I'll send out a notice. We'll close your discovery. And May 11th at 10 o'clock will be our next pretrial date. By that time, I should have whatever motions, dispositive motions we're going to have, so that by our next pretrial, we can calendar those motions and figure out where we're going on this thing.
Okay. May 11th, 10 a.m. Did you say, Your Honor?
Yes, sir.
Okay, thank
Is there
you.
anything else we can do today, Joe?
Okay.
I have a question. Yes, so that May 11 date will be considered as a pretrial conference?
Yes, sir. Yes, sir.
Now, what confused?
I'm sorry, go ahead.
What confuses me is it doesn't take much to confuse me. On the motion precipice, there's a place where you need to fill in a hearing date, and I'm not sure should I just leave that blank then?
Just leave that blank,
That's easy to do. I can do that.
because what we'll do is on that,
Right.
we'll see where we are. Let's say for purposes of our discussion, you have filed your motion, but Mr. French has not filed his response. Obviously, that'll give us a different hearing date than if you have filed your motion and Mr. French's response has also been filed. See what
I've
I'm
got
saying?
it.
May 11th.
I have it. I got it. Thank you.
Let's get those motions in, gentlemen, and we'll
Thank you.
figure out where we're going when we get there. Now, there's one more thing, of course. Since you guys, I mean, you're experienced lawyers, you got P numbers that are not in the eights.
Mm-hmm.
Settle the case. This ain't complicated. Is there
I'd
an
love to
account?
do that.
Is there an account? Yes or no? Is there a balance? Yes or no? What is it? Come on. We know where this is going. Let's get it done. May 11th, gentlemen, 10 o'clock. Thank you both for coming in. We're off the record.
Thank you.
Over to your
Thank you,
respective
Judge.
Thank you,
Have a
Judge.
good
Have a
day.
good day. Thanks. Thank you.
What? We are on the record calling file number 201668852, Discover Bank versus Lynette Faison. We were last together on this file on March 16th, 2021. At that time, the parties in court agreed today, April 13th, 2021 would be our next pretrial date, 10 a.m. Written notice of today's pretrial was sent to the parties on that date. Matter scheduled for 10 o'clock. It's currently 10:31. Your appearance.
Thank you. Good morning, Your Honor. Daniel Best, P58501 on behalf of plaintiff Discover Bank.
Mr. Best, I don't have a defendant here.
I had called her attorney. I left a voicemail. I have not had a return call from her. I did provide her the Zoom information. I know my intention this morning was asked for a date for a motion for summary disposition. Given that she has failed to appear and I have not gotten discovery responses or anything on this file, I am tempted to request a default judgment, Your Honor.
The default of the defendant, Lynette Faison, is hereby entered. Defendant having failed to appear, no good cause, that failure having been shown. This is a some certain case, sir.
That is correct, Your Honor.
Please submit your default judgment.
The amount of damages are $9,779.72. We've incurred costs of $146.80, representing $71.80 service fee, $75 filing fee. In addition, we're requesting a $75 statutory attorney fee.
I will look forward, sir, to your default judgment.
Very good. I'll submit that under 7 day, Your Honor.
Thank you, sir. We're off the record.
Thank you. Have a good day.
You too, sir. Good morning, counsel.
Good morning.
Counsel, you failed to appear on 20166-852, a 10 o'clock pretrial. You're calling in now at 10:49. You failed to appear and we entered a default. The judgment, the plaintiff will be sending in his default judgment under the 7-day rule.
Okay. Yeah, I was having a lot of difficulty. All right, so the plaintiff will be entering default.
The default was entered. He'll be sending in his proposed default judgment mail.
Okay.
Okay,
Okay.
have a good day.
Very good. Thank you.
Yes, ma'am. Show up. Who's this? All right, let's get started with Mr. Warner. Good morning.
Good morning, Your Honor.
You're here on which file?
I'm here on 20-156683. It's open MRI versus homeowners and auto owners.
Okay. I don't have your opponent yet, so you're off to the waiting room.
Thank you.
Mr. Alton, what brings you here?
I'm here on complete imaging versus City of Detroit.
Okay.
As am I, Your Honor.
Mr. DeKrug, you're here on that file?
Yes, Your Honor.
All right, well, then you other gentlemen will be off to my waiting room. We'll do your files. We got a set that's ready. All right. Mr. Warner, we'll put you in the waiting room.
And Judge, if we could get a chance to talk real quick before we go on the record, that'd be great too.
You want to do that?
Yep, just quick.
All right, give me a second. Let's see if I can get the technology to work for me.
You lose us, we'll just call back in.
You're not gonna get rid of us that easy, Your Honor.
All right, let's see. This is gonna be Mr. DeCruz and Mr. Alton. I don't see Mr. Alton. Oh, there he is. Mr. Alton assigned to room 1. Mr.
Thank you,
DeCruz
Your Honor.
assigned to room 1. Okay, that should be both of you. All right, sir, what brings you here today?
Good morning, Your Honor. I'm here on Meyer Credit Union v. Andre Harris.
Okay. You're representing Meyer?
Yes, I am, Your Honor.
I don't have the other side as of yet, so off to the waiting room with you.
Okay, Your Honor. Your Honor, if I may say, it probably it would be out of the ordinary if this defendant showed here. So I just wanted to let you know, we've given him notice of this, but he may not show.
Yeah, I understand that that's the case, but the problem that I have is in the rare occasion where they do show, they've got an opportunity to be heard.
Absolutely, that's fine. I'll wait in the waiting.
Thank you, sir. All right, so this is Warner and Beverly. This is 683. 683. Okay. All right. I believe I have everyone here. I don't have Ms. Beverly's face. I have her name here, and she's supposedly in the meeting. So let's give her a couple of seconds to clear the whatever electronic hurdles we have, and we can get started.
Thank you.
Okay. Let's call the file. This is 20156-683. Open MRI of Livonia versus Homeowners Insurance, date and time for pretrial. It appears that our discovery is now closed in the file and that the prior co-defendant has been released. Could I have your respective appearances?
Good morning, Your Honor. Carolyn Beverly on behalf of the plaintiff, P44028.
Good morning, Your Honor. Derek Warner on behalf of defendant homeowners, P number 81962.
Where are we on this file, folks?
Well, Your Honor, we had a delightful conversation this morning, very early this morning. Counsel has a first-party case that is going to case evaluation, and he invited me to attend that. Last time we met, he had an MSD pending in Wayne County Circuit Court before Judge Sullivan. He thought he'd have an opinion by now. He has not received it. And I will share with you what I shared with counsel is, I don't have a problem doing the case evaluation, but the last time I agreed to do a case evaluation with homeowners, we went and 5 minutes, a little bit less than 15 minutes into it, they said, forget it. And all the parties that they had invited there were just left. And then I got a bill for $170 after the facilitation, which in that case they were doing in lieu of case evaluation. So I'm a little leery saying that I'll go and do something and being, stuck with a high bill here. This case has been around a long time. We gave a demand. There's been no response to it. And so I don't have a problem doing the case eval, but I don't want to be bound to it necessarily. And I certainly really don't want to pay for it.
Mr. Warner.
Thank you, Your Honor. And just to echo what Ms. Beverly had mentioned, so for the motion, I'm looking at the register of actions. I've been trying to call the court. They have it scheduled for a review hearing tomorrow at 8 a.m. So I'm going to call them if I don't hear from them again to get an answer on that. I do apologize. I don't know what's going on with Judge Sullivan's court. Regarding the case evaluation, we have a case evaluation scheduled in the claimant's main suit. We haven't gotten a date yet, but we were told it's going to be in June. I wanted to extend and extended to Miss Beverly to have her participate. Was hoping we could find a way where if she could participate but not pay the fee necessarily, just so we could have maybe a mediator number suggested. I wanted
Here's
to
the
make it easy.
problem that I have. You're talking about participating in the circuit court evaluation, case evaluation. I don't have the authority to waive fees in the circuit court evaluation. So what I would think would be your best bet, you'd have to approach Judge Sullivan. You two craft, whatever kind of order you want to craft, and have Judge Sullivan sign it. Because I don't have the authority as a district court judge to waive something in the circuit court.
Okay,
Now you're talking case evaluation, not facilitation.
correct. Case evaluation, not facilitation.
I lack the authority to tell circuit court what to do.
Understandable.
So
Okay.
I think what we should do here, just keep a control date on this, just to not lose track of it. And then I'll give you a May 11th return date. And that'll give you time to find out, first of all, whether or not you're going to be able to get involved in that facilitation on terms that are acceptable. And secondly, by that time, you should also have a handle on what, if anything, is going to be the decision on the SD motion by Judge Sullivan. Does May 11th at 11 work for both of you?
Yes.
What about you, sir?
Yes, it does. Thank you.
All right. So what I'll do is I'll simply adjourn this matter to May 11th at 11 o'clock. I note it as a pretrial. And then I'll just note case evaluation. Question mark. Motion for summary disposition in circuit court. Question mark is with. So, sound like we're done.
Yes.
Okay, May 11th, 11 o'clock, and you guys make nice to get the case settled. Thanks for
Thank
coming
you.
in.
I have one more with you, Judge, so I'm
Okay,
gonna
I'll
stay on
put you in
the-
the waiting room then.
Okay.
Take care, everybody.
You take care, Mr. Wortman. Mr. DeCruz. And Mr. Altman. Okay. One case down. Let's do our next file, which is Complete Imaging versus City of Detroit, 20159-823, your respective appearance.
Good morning, Your Honor. Joe DeCruz on behalf of the plaintiff, P84445.
Good morning, Your Honor. Michael Lawton, Pete 81884 on behalf of the City of Detroit.
All right, you settled?
No, Your Honor, we did something even better. We did something even better. We are going to, the plaintiff is going to move to intervene in the underlying patient case.
There's a circuit court case you're gonna move to intervene in?
Yes, Your Honor.
Okay, then here's what I'm going to do. I'm going to give you a control date, a return date for me for May 11th. That should give you time to get your motion filed and get your decision from the circuit judge as to whether or not you'll be permitted to intervene. That work for everybody? May 11th at 11 o'clock?
Yes, Your Honor.
Yep.
Okay. Somebody's unhappy. I hope that's not a client.
No, that's my daughters. And they're standing outside of the door and
And they want to know why.
And I literally just muted it and told them to stop crying. I'm in court.
It's hard for little people to understand that.
Your Honor, at least they didn't come in this time and jump on me during court like they did the other day.
Mine can't walk yet. I'm a little thankful for that right now.
Yeah.
Okay, guys, so we'll talk again, and that's gonna be on May 11th at 11 o'clock. And by that time, we should have a decision to know whether or not you're gonna be able to intervene in that circuit court matter.
All right.
Anything else, gentlemen?
That's it.
All right, let's be safe. Take care of yourselves and your families.
You too. Thank you, Your Honor.
Thanks for coming in. Oh, I'm gonna take these two. Hello? Who is Kawan Grace?
Hey, how you doing? I'm Kwan Grace.
What brings you here, sir?
I was trying to resolve a warrant that I have in my name, and
Okay, you're on the wrong call, sir. I'm on a civil docket. I don't do criminal cases.
no, it's not a criminal case. It's a traffic warrant. A warrant.
Yeah, it's not that you're on the wrong judge's docket. I do not have traffic warrant in front of me. I'm doing a civil docket. I don't have anything to do with traffic cases at all. So you're in the wrong place. I can't help you.
Just about 100 years on, and that recording by the Philadelphia Orchestra of Music Director Lenny Kazes again in 1913, music changing ballet by Nicholas Stravinsky to Robert Spring. On WOCJ, FM, report is followed by the Ann Arbor Symphony Orchestra. Celebrate 92 years of A2SO. Information on your Ann Arbor Symphony is at a2so.com. Philadelphians are back again. This time, Henry Davis is in charge, and the soprano is Lucia Park, with Doug Butler as liaison instructor.
We are on the record calling case number 2016573, Meyer Credit Union versus Andre Harris and Tiffany Harris. Matters before the court today on a motion filed by the plaintiff in this file. Could I have your appearance, please?
Good morning, Your Honor. May it please the court, Stephen Bequicchio on behalf of Meyer Credit Union.
Okay. This is your motion, sir.
Thank you, Your Honor.
And rescind the dismissal. This matter was scheduled for hearing today by a notice sent to all parties. Notice is dated March 29th, 2021. Matter set for hearing at 11 o'clock. It's now 11:31. Sir, your motion.
Thank you, Your Honor. Your Honor, this case was dismissed on or about February 11, 2021, pursuant to what is believed to be a notice of intent to dismiss here. This case was filed back in October of 2020, in which the summons was entered about a week later, and the summons and complaint was served upon both defendants on 12/1/20. We have filed that proof of service after the complaint was served, and it appears as though the court has no record of receiving that proof of service, although we did file it. Now, obviously, with COVID and things like that, things like this have been happening where documents are not being found. But the case has been served, and we did file the proof of service with our motion evidencing that it was indeed served by the process server upon both defendants personally. They were aware of this case and did not file an answer. And what prompted this was the dismissal. We looked back at what happened here, and it looks like, again, this was more of a kind of a housekeeping administrative issue rather than a service issue. The case was in fact served. So we're asking this court, because of that, to reinstate the case so that it can go further. In light of the non-answer, our intent here would be to file a motion or an entry for default and default judgment that we will serve upon the defendants again so that they could, in theory, object to that if they wish.
Sir, I had a chance to review your pleadings. It appears that you did make timely personal service on each of the defendants, and obviously they have failed to answer. The motion to reinstate the case and rescind dismissal will therefore be granted. I look forward, sir, to your motion for the entry of default judgment.
Thank you, Your Honor.
We'll send it on out to you today.
Thank you.
Thank you, sir. We are off record in this file. Let's go, Ms. Beverly.
Hello.
Good morning. We are on the record calling case number 20158-046. The file is entitled Open MRI of Livonia versus Esurance Property and Casualty Company. By notice dated March 29th, 2021, this matter is scheduled for hearing today, April 13th at 11 o'clock on the defendant's motion to set aside the default. Default was entered in this matter when defendant failed to appear for pretrial in this matter. This matter's the motion is calendared for 11 o'clock. The defendant's default was entered on January 28th, 2021, when defendant failed to appear. It's now 11:35. I don't have a defendant on the defendant's motion. Your appearance.
Good morning, Your Honor. Harolyn Beverly on behalf of the plaintiff P44028.
I've got a motion from a defendant who's failed to appear from pretrial. The motion is to set aside a default that was entered when the defendant failed to appear for pretrial and the defendant failed to appear for defendant's motion.
That's right, Your Honor. And I would like to make a little bit more of a record here.
If you would.
Your Honor, this complaint was served on August 20th, 2020. Defendant responded on, they responded thereafter. We served interrogatories, requests for production of documents, and RTAs on September 22, 2020. On January 11th, 2021, we appeared before the court and defendant agreed to a stipulated order regarding defendant's discovery responses because they had not responded to any of our written discovery other than the RTAs, which they responded to on October 8th of 2020. So we went ahead, we submitted that order, and this judge, you entered it first on January 6th and then again on January 11th. Because you guys closed down, there was a little bit of lag time, but they were supposed to provide the written responses to the interrogatories and the request for production of documents. They have not done so. I went through my email today and I searched for emails from opposing counsel, who is Zachary Anderson, his legal assistant, who is Heather Silcott, another legal assistant named Shaquila Lewis. I have searched for all three of them and I do not have any written responses from them on the interrogatories or the RTAs as this court ordered in January of 2021. They did provide the claim file and the claim log, but no written responses, which is what we asked for. And that was the order that was entered. We have sent a demand to them back, very early, back shortly after the complaint was served. We don't have written responses from them. This will be the second time that they've not appeared. Your Honor, I submit that they're just flat out ignoring this case and being somewhat disrespectful to the court and to counsel because I can only do so much. And I feel like everybody has given them plenty of opportunities to do what they're supposed to do in this case, and they've not done it. I was going to ask for costs, but they haven't appeared. So the default, I think, should remain, and I can file today electronically a motion for a default judgment and go from there. I did not file it because they filed this motion to set aside, and of course, the court was closed. But I don't know what to say here, Your Honor.
Yeah, I think that the matter before me is limited to the motion to set aside the default. And the motion to set aside the default is denied for the reason that the moving party, defendant, has failed to appear. So any motion that you wish to file going forward, just go ahead and take the normal steps to file a motion. When I receive it, I'll calendar it and we'll move on from there.
Okay, and since we will be submitting it via electronic, my office will overnight your judge's copy to you in the mail.
Well, you need to overnight that along with the motion fee and all that stuff.
Well, we can file motions electronically in 36th District now, and I can use my credit card to pay for the motion.
Well,
So
they were taking money. I knew they could take electronic filing, but I didn't know taking money electronically. Good. for us.
Yes, with a transaction number and everything. So,
That's good to know.
you know, so I'll overnight our motion to you along with the letter. You know, maybe I'll give you the transaction number so you can know that it was paid for.
And what I will do is I will send out today my handwritten order denying the motion to set aside default for the reason that the moving party defendant failed to appear.
Okay,
Okay, thank you.
thank you. Have a great one.
Day, be safe.
Bye-bye, you too.
Off the record. That concludes the meeting for today, our docket for today.